Our best friends don't live here, and so they're all here now.
Okay.
For the weekend.
Or weeks or, you know, whatever.
When I got home from the last meeting, Cindy said, I saw you guys on YouTube
Oh.
at the beginning. She's half of Charlotte Island, came on. She's-
Well, there she is.
Good evening.
You look better on
So we
television.
need to call Pat and see where she is.
I don't,
Did she respond to the email?
my understanding is yes, she said she would be here.
Did Laura bring her puppy?
No, I'm at my actual office right now, so
Oh, how boring.
I didn't want to have those distractions again. He's wonderful, but not always quiet. No, it's in that, it's on the left,
I think you did.
where she sits. And the bot really good.
Oh. One more than half, I think.
Jane calling.
So Shane's going to go see if he can get a number for Pat, who's supposed to be here. Okay, great.
Oh, hello. So do we want to start? It is 6 o'clock and everyone's gonna come. Yeah. All right. Would you rather we wait for the,
So you have 5 regular members and 2 alternates, or what's your membership? Sorry.
6 members and 1 alternate.
but one of the women who's supposed to be here is not.
Oh, I'm sorry, do you have 4 present or 3?
Or.
I could, oh, there we go, Lisa. I thought you only had 3 present and I was going to say you had to wait, but with 4, yes, go ahead.
Go ahead, all right. So it is Tuesday, July 1st. We'd like to call the zoning board of appeals regular meeting to order. Can we have a roll call, please?
Brown,
Here,
Nibbs,
here.
Marshall,
Present.
Stein.
Present.
Next item is the approval of minutes. Everyone read them?
I read them, they're quite lengthy, and I don't know if I could find anything to add or subtract from it, so I would make a motion to do.
All right, it's been moved by Mr. Nibbs and seconded by Mr. Brown to approve the minutes of June 3rd, 2025. Are we all in favor? Say
Aye.
Aye, thank you. That approval passes. Next, item number 4 is public comment. Would you like to say anything?
I think we covered everything, so unless the board has any questions for us.
Okay, so you're content at this point? So the next item, number 5, is closed session. I need a motion to adjourn to closed session to consider material exempt from discussion or disclosure by statute pursuant to MCL 15.2681H, specifically identified as attorney-client privileged with privileged written legal opinion.
So moved.
Seconded.
Okay, moved by Sue Stein and seconded by Bill Brown. All in favor?
And roll call.
Oh, roll call for this. Okay, let's have a roll call.
Brown,
Yes.
Nibbs,
Yes.
Marshall,
Yes.
Stein.
Yes.
Okay, it's been moved and approved to go into closed session, so we will adjourn, but obviously we are conflict. Thank you for your.
Am I switching to the other Zoom, Lisa, or staying on this one?
We will leave here and meet up with you.
Okay. I will see you on the other Zoom.
Shane? We don't have to make a motion to come back into open session, do we? We do? Yeah. So, is there a motion?
Motion to come back into open session.
For a second?
Second.
Mr. Nibbs caught it. So it's been moved by Pat and seconded by Jim to come into open session. All in favor?
Aye.
Yes. Okay, we're good. We're back in open session. Let's move to number 6, old business. Case number 874. Powell's application on remand. Consider whether there was a vested right in operating a short-term rental on the first floor at 215 West Mitchell prior to the enactment of the new ordinance. So how would we like to open this up?
I move that we affirm the zoning administrator's determination.
Okay, is there a second for that?
I'll second that.
All right, it's been moved and seconded to affirm the zoning administrator's decision. So now we can have that discussion. Who would like to lead off on that discussion?
Well, I'll take a shot at it.
Okay.
Because I was the only deciding vote on this the first time. I'd like to clarify my position for that. And the issue of the building permit seems to be very important. And Powell's thought they had one, they signed one. And the builder didn't turn it in and file it. And also, I feel that they made it clear from the very beginning, even before they purchased the property, that they were gonna use the entire building for short-term rental. And I think our job is to put the human factor in this. I know if you just base this on technicalities, Lisa made the right, well, it wasn't her determination, but the city made the right determination. But when you put in the human aspect, which is what our job is, I feel like they went in thinking they had a permit. They spent money doing the things that they needed to do. And I asked you, Kate, I've worked on your house. Did you ever ask me if I got a permit?
No, but I know there's supposed to be one, and if you didn't, then you were not following the law.
But there was one, and I had inspections, I had everything, but you didn't know that or ever asked for it, did you? So I feel I can justify them being in that same position. They didn't ask to see a permit because nobody ever does, in my experience.
I mean, since you brought that into me, I would say another case would be my next door neighbors who were doing work on their garage, intending to put a second floor residence there. And I noticed there was no building permit, and I called the county and they couldn't do it.
Mhm.
So I disagree with you. I disagree with you fundamentally, that your argument is that we should apply empathy or the human consideration. I think we are supposed to follow what is legal. And we have to find what is legal. And there's no supporting evidence that the allegation that the contractor lied has come forth. So that is moot. We don't know what that is.
That's true.
And I'd also like to disagree in that there's a difference between a business not getting a building permit and a residence not getting a building permit. As a business owner, you have a responsibility to follow through on everything yourself. And because things are going to come down the pike constantly. And it's your responsibility to make sure that the I's are dotted and the T's are crossed. If it was my home, I could be naive, but if I'm a business owner, I can't afford to be naive because other things could come and really hurt me later down the road if I haven't checked it out myself. But I also agree with Kate is that we're supposed to rule on the finding of facts and not on empathy. I have a great amount of empathy for this whole situation.
Right.
I think breaks my heart that people are trying to do these kind of things and open up these kind of businesses. I've owned my own business for many, many years, and I've been in a lot of trouble before because of things I didn't do. That's not true. I've been in trouble before. But the fact is, we had a certain amount of findings of facts. We had a presentation given to us. We had spreadsheets. We had information given to us. And that's all I feel we can make a ruling on is what was given to us and what the case law is. That's been our advice from our attorney, but we were told to rule on a finding of fact of vested right based on the amount of money that was spent and the permit.
Well.
We didn't even ask about the permit is what what most of us feel, or what I feel, I should just speak for myself, is a really important part of of a process. Reason why I say that, how important it is, particularly for us, is that we can't determine whether something was done to code. We can't determine whether something is done that supports life safety. We can't determine anything based on photographs and a spreadsheet. So I can't make a decision that something is a measurable, I don't feel I have a measurable account that the work was done to code and that it's going to protect the owner, the operator of the business, the city, and the people who are renting the property. It's not my job to make that decision,
So I don't think that's pertinent to what we're trying to decide here.
but that's what a permit and a permit is,
Right,
that's what a permit is for.
exactly.
So not having a permit, how do I make a determination that I spent 57 cents? How do I know that that 57 cents was spent the way it needed to be spent?
I'm a little confused. I think if I could use Mr. Zayas's, page 5 in his brief, or new brief, or what, the second one we got, he cited, if I can quote, under all of the cases cited herein, a building permit or its counterpart, a permit to commence operations is the sine qua non for obtaining vested rights. An approved site plan is not a permit to build. So we're talking about two things.
Site plans are a building.
We're talking about whether or not the building permit existed with this case and whether or not there was substantial investment or change of the nature of the business. There are two things. And I think you're kind of putting them all together.
No, I'm saying they spent money, but I can't evaluate that money. That's not my job to evaluate the money.
Okay,
And a building permit and inspections would have evaluated the dollars spent. I know they spent the money. She gave us clear determination that they spent the money.
You know, the remand to us from the judge was just determine whether a vested right has been created. So we, with the help of our attorney and our own reading of all these cases, vested rights. What's the role of a substantial amount of improvement? What's the role of actually having obtained a permit? Those two things are pretty, they're driving bulk of the question and the resolution. The not having a permit, the work by definition, the cases tell us, the work is unlawful. And law doesn't want to reward unlawfulness. Here, the applicants may well have been duped by their contractor into believing that he had a permit. My reading of the material would have been probably would need building, plumbing, electrical, and he had none. The cases. The cases are pretty numerous that if you don't have a permit, some of them are very explicit with that language. If you don't have a permit, again, the work is unlawful. But if you don't have a permit, you can engage in a whole lot of work and spend a whole lot of money that doesn't give you a vested right. So,
Question,
yeah,
one of the ways I've heard it described, or we read it described, was and I'm not gonna use the correct word, made a substantial change to the new use. I think that's demonstrated. But if we have to evaluate strictly on the money spent, how do you evaluate the money spent if it's just a line on the page?
I understand what you're saying. We would not, if they had obtained the building permit and the resulting multiple
Drawings.
inspections and drawings, it may or may not have matched their calculations that they provided to us. But I don't think, frankly, at least for me, I don't think that we can deny that very substantial physical work was done, and it cost money. And it did change the interior,
Change the use.
but that in itself, I don't think you can get over the hurdle of to have a permit. Was the work lawfully done and you didn't have a permit to boot? I think that
And done to code.
as required as, I think it is required as part of the real totality of the vested right legal analysis. You need both.
I go back to, how do you measure the work that was done if you don't have a permit and an inspection of the work that was done? How do we measure that? How do we?
I don't think we
rate
need,
that?
I don't think we need to measure it. I mean,
We're supposed to rule on whether they spent money.
right, they did, and they gave us.
They spent money.
They spent money and they listed what it was spent on. They showed before and after pictures of dates. And when you say a vested right, when I looked up vested interest in the dictionary, it's vested right might be something different, but I think what we're determining is vested interest. It's a personal stake of involvement in an undertaking or state of affairs, especially one with an expectation of financial gain. Only reason I say that is because when you say vested right, that might mean something different, but I think what we're talking about here is a vested interest.
No, I disagree with you. We are talking about vested property rights. And all of the cases that have been cited as a standard are vested property rights. They have a right for a use because of certain conditions. And the two conditions are, and if you read these cases, a building permit and work of a substantial nature. Sue is saying she's not sure how to determine work of a substantial nature. Is there anybody here who's on the board who thinks that they have a building permit? They do not have a building permit, so they don't meet that standard, that half of the standard. Even if you say, okay, they did the work, I'm not sure if it's really work of substantial character, but it is work, it's money, it's $40-some thousand, blah, blah, blah. That's something you can say they've done, but they did it without a building permit. So the governmental standards that are required were not met. And regardless of our sympathy or personal experience with contractors who don't get permits, and I know a couple who don't, if they work in the alley and they can get away with not dealing with the county. You know, I know all of that happens, but that's not what our charge is. Our charge is to determine whether, in this case, the standard for vested rights has been met. And Mr. Zaya said there's not a bright line correlation here, which is true, but all of the cases talk about different instances where vested rights are questioned. So there isn't necessarily a bright line with any of those cases, but there is a standard. And I think that's what we have to decide. And we have, from our packet in the past and other things that I've certainly done. I mean, there was one case that I saw that went to the Supreme Court, Michigan Supreme Court, and in added comments, one of the judges said, I don't think we should have anything about work of substantial character. It's too subjective. It should be building permits. Now, that was just a sideline opinion, but that's, to me, very concrete. Is there or is there not a building permit?
It's measurable.
It's measurable,
It's a fact.
yes.
It
And
may be the opinions of the
And
inspector,
all
but
of these cases mention a permit,
yes, that's
even if they don't say it's a bright line, they all mention
they all say that that's a
that
requirement.
that's, yeah.
And the, maybe it's going to deal with it for the Bevan, what's this, Michigan Supreme Court case, where actually it was very clearly stated there, where building permits have been applied for but not issued,
Right,
vested rights have not acquired, even though significant monies may have been expended by the applicant.
that's right. So give, affirm, yes, they've spent money, but there was no building permit.
All of this problem with the had had the builder not engaged in that fraudulent behavior, and he had just done what he had contracted with the applicant to do. I'll take care of the permits, I'll do all this building. We wouldn't be here. The fault, it is not ours. It belongs to the person who did wrong, and he should stand responsible. But our narrow directive from the judge just determine if a vested right of a non-conforming use prior to the date of the ordinance, whether a vested right exists for the applicant. Really narrow. Yes. Wish we could redo what happened to them. No, we can't. We were restricted to following the judge's direction and determining from the information that we have whether a vested right at that time existed. And so with the guidance from looking at all these cases, looking at their material, it's almost unfortunate, but I have to determine, in my estimation, in my opinion, that it is clear that a vested right did not exist for the applicant at the time of the non-conforming use prior to the change of the ordinance.
Is there any more discussion? We have a motion. Do you want to take a vote, or do you have anything else you want to say?
Laura.
What's that?
Oh, sorry, Laura.
Did you, are you saying?
Laura has something to say.
Laura has something. to
Laura
say.
has something to say.
Sorry.
I couldn't unmute myself, so sorry about that. All I wanted to say was your motion was to affirm if you are going to consider a resolution. I guess I want you guys to decide, are you making that motion and then doing the resolution, or how are you gonna do this?
Well, there was a motion made to affirm, and now we have to have the motion, the actual motion. That's what you're saying.
So you had a motion and a second and discussion. So you do either need to vote on that or amend or withdraw it. If you wish to approve a resolution, that's not the motion that you have on the floor.
Right, okay. So we need to have, so we've had the discussion subsequent to the motion, and now we would need the motion. Right?
You did the motion, but your motion is just to affirm. You didn't make a motion to approve the resolution.
Okay.
I motion we approve the resolution to affirm the zoning administrator's
I
determination.
see what you're saying, sorry.
They need to withdraw the first one.
Thank you.
Okay.
So you have to withdraw the motion that was already made and
Okay. I withdraw my first motion to affirm, and I'm making a motion to affirm okay, now I got confused.
Approve the resolution.
To approve the resolution to affirming the zoning administrator's determination. Sorry about that.
Should we read that into the record?
You certainly can.
I'll read that into the record.
What am
Do
I
you want-
reading?
Do you want me to read it or do you want to read it?
The whole thing.
Yeah, go for it.
Okay. Up here. All right. This is what there's a motion that, but well, actually, why doesn't somebody second that motion first, if there's going to be a second? Okay. The motion on the floor is a motion to approve a resolution regarding appeal of zoning administrator's decision by John and Mallory Powell and the MIT LLC affirming zoning administrator's determination. Whereas pursuant to the Michigan Zoning Enabling Act, the City of Petoskey Zoning Board of Appeals has the authority to hear and decide questions that arise in the administration of the zoning ordinance and appeals of administrative decisions. I'm not going to read the statutes out loud, but they are there. Whereas on February 14th, 2024, the ZBA received a written appeal from John and Mallory Powell and the Mitten LLC, collectively the Powells, challenging the zoning administrator's January 31st, 2024 decision denying a short-term rental license for the first floor of 215 West Mitchell Street, Petoskey, Michigan, in the B3 General Business District pursuant to case number 874. And whereas the ZBA conducted a public hearing on June 4th, 2024, affirming the zoning administrator's decision, citing insufficient evidence of a vested right, failure to obtain planning commission approval, and noncompliance with the zoning ordinance. Whereas on July 12th, 2024, the Powells appealed the ZBA decision to the 57th Circuit Court for Emmett County. Whereas on April 7th, 2025, the Circuit Court remanded the case to the ZBA, finding that the prior zoning ordinance permitted short-term rentals on the first floor without planning commission approval, and directed the ZBA to determine whether the Powells established a vested right to operate a first floor short-term rental prior to the enactment of ordinance number 794 on December 18th, 2023. Whereas in accordance with the Michigan Zoning Enabling Act and the Circuit Court's remand order, the ZBA scheduled and held a public hearing on June 3rd, 2025, during which the ZBA received comments and reviewed supplemental submissions from the Powells, including photographs, expense records, floor plans, and a timeline, as well as the underlying 336-page record and the June 4th, 2024 hearing transcript. Whereas the ZBA has evaluated whether the Powells renovations before December 18th, 2023 constituted work of a substantial character under Heath Township versus Saul, which states to constitute a legally cognizable non-conforming use, work of a substantial nature beyond mere preparation must materially and objectively change the land itself. And whereas the ZBA has considered the case law, including Schubner versus West Bloomfield Township, which holds that under all of the cases cited herein, a building permit or its counterpart, a permit to commence operations, is the sine qua non for obtaining vested rights. Moskovich versus City of New Buffalo, Bevan versus Brandon Township, which holds that where building permits have been applied for but have not been issued, vested rights are not acquired, even though significant sums may have been expended by the applicant. City of Lansing versus Dolly, which holds that the test in each case as to whether the holder of a permit has acquired vested rights thereunder is not whether he has spent much or little in reliance upon it, but rather there has been any tangible change in the land itself by excavation and construction. And Dorman versus Township of Clinton, noting that under Michigan law, a landowner does not possess a vested property interest in a particular zoning classification unless the landowner holds a valid building permit and has completed substantial construction. Whereas the Powell's renovations included demolition, reframing, and installation of 4 bedrooms, 2 bathrooms, and a kitchenette, with a total cost of $46,925, and with 90% of that cost allocated to the first floor, but the renovations were conducted without the required building permits. And whereas the Powells admitted in their ZBA memorandum, circuit court brief, and supplemental memorandum that their contractor failed to obtain the required building permits. Now, therefore, the Zoning Board of Appeals resolves as follows. Number 1, the ZBA hereby affirms the zoning administrator's decision of January 31st, 2024, denying a short-term rental license for the first floor of 215 West Mitchell Street. Number 2, this decision is based on the following reasoning and factual findings. A, the Powell's renovations, while substantial, were unlawful due to the absence of required building permits. B, pursuant to the case law referenced above, unpermitted work cannot establish a lawful prior use necessary for a vested right. C, the Powell's reliance, on their contractor's assurances does not excuse their failure to secure permits, and no permit applications were submitted to determine if permits would have been granted. Any and all resolutions that conflict with this resolution are repealed to the extent necessary to give this resolution full force and effect, and that is the end of the resolution.
So, is there any further discussion, or do we call for a vote? We call for vote. Sure.
Stein,
Yay.
Brown,
Yes.
Hannicky,
Yes.
Nibbs, Marshall.
Yes.
Okay.
Back to court.
Who's part of the business? And we are going to move. Okay, thank you, Laura. So now, part B is discussion on proposed changes to Appendix A, Article 20, Section 2007. Lisa, take it
So, at the last meeting, we discussed possible changes, and it was requested that staff come back with different options on amending Article 20 as it refers to variances for both use and setbacks. I'm drawing a blank.
building.
But yes, essentially, there's 2 different types of variances, but it addresses both of those. So I have stated the current ordinance language, and then there are 2 other options listed. One in which, hopefully you've had a chance to read this, because it was discussed that there be a way to limit a zoning permit to extend the life of the variance, so to speak. So option 1 was amended to include language that says within 1 year of the date of approval, the applicant shall obtain a zoning permit and a building permit, commence erection or alteration of a building, and be progressing toward completion per the terms of such permits. Should the applicant fail to meet the above stated criteria, the permit shall be considered expired and the applicant shall be required to apply to the board for a variance. That's option 1, and that's under both of the variance allowances. Option 2 is the one that gives them the opportunity to come back to the board and ask for an extension, in which then they would not have to go through the whole approval process, they would need to come back and state to the board their reasoning for needing an extension on the initial variance that was granted.
I'm gonna make a copy. Anyone else dying to speak?
Oh, yeah.
I think for me, option one, number one is good, except that the process is the zoning administrator grants the zoning permit, right? And that permit is sent to the county. And the county issues the building permit. How does the zoning administrator know that that requirement is met? That the building permit has to be issued within the year?
At this point, it would just be a matter of following up. So essentially, if their zoning permit, if they don't start the work, they would have to have a building permit to start, especially a building. They would have to have that permit in place.
I guess
In order to, upon, before the expiration essentially of the,
that's a concern to me that it's
No,
not
there's no-
stated.
There's no process.
The process is not clear. And then the other thing is, it doesn't say, and the administrator shall not grant an extension unless it is approved by the board. So those are my comments about that. And then I have to read out loud number 2, and I noticed, Lisa, you didn't do it, so.
oh, sorry, well.
No
I didn't.
order or variance granted by the board permitting a use of a building or premises shall be valid for a period longer than 1 year unless such use is established within such period, provided, however, that where such use permitted is dependent upon the erection or alteration of the building, such order shall continue in force and effect if a building permit for said erection or alteration is obtained within such period and such erection or alteration is started and proceeds to completion in accordance with the terms of such permit. Should the applicant fail to meet the above stated criteria, the permit shall be considered expired and the applicant shall be required to apply to the board for a variance. I have 2 master's degrees, like, I don't get that. I can't read that and have any idea as a person who's gonna do something. I wouldn't know what that meant. Maybe it's just me.
So-
No.
So the first question is, who is the board?
Was it
Board of
ZBA?
Appeals.
Should that not be used as zoning board of appeal? And
I
we're only granting a zoning permit. We have nothing to do with, so you keep using permit without defining whether it's a building permit or a zoning permit. And
It's neither, because the board doesn't issue.
Some of that is just how the original ordinance,
Yes.
right, there,
It's
some of that
also very
is
confusing.
not new language.
Yeah.
So that's, I'm just pulling up.
I would think that could be cleaned up so that it's,
Yeah,
streamlined
Yeah.
and maybe not such a run-on sentence
sure.
with so many suches and therefores and.
I'm a huge fan of plain language, so if we want to just rewrite it from scratch, I don't have a problem with that. I think the intent was to make the most minor changes to effectuate what we were trying to do.
Right.
Yeah, this is a 1 paragraph sentence.
It's essentially what's existing with the addition of
More words.
that. Yes,
And
essentially.
the whole article is called the Board of Appeals, and then within it just refers to the board. So if we are gonna start saying zoning Board of Appeals here, it'll be inconsistent with the other sections in the article,
Got it. Okay.
or we can amend the whole article.
Yeah.
Or suggest that the planning commission amend the whole article, I should say.
I guess, I mean, I appreciate that with number 2. Does anyone agree or disagree with what my comments were on the first part of it? The process being cleared up? Or,
Well, if it says, I don't have a copy in front of me, I'm sorry, I've written down here, but doesn't it say that the permit shall be considered expired? I don't think it needs.
well, it says that originally. No order of the
Okay,
board permitting the erection of a building.
But this says, and the applicant-
Here, except that the zoning administrator had the option to extend.
Right, but so this says, and the applicant shall be required to apply to the board for a variance. I think that's pretty clear. That you can't go to her, you have to go to the board.
And wasn't that the whole purpose of amending this? Yes.
But I think
That's really all that needs to be said.
That needs to be crystal clear.
It needs to be crystal clear.
That unless the applicant fails to meet the above criteria, the permit shall be considered expired and be required to apply to the board for a variance. So that sentence maybe has one extra word.
So do you think there is anything that needs to be added to make it more clear? I mean, I feel like it's pretty clear the way it is.
Or should it say that they should apply for a new variance?
Yeah, it would have to be a new variance.
Yeah, maybe it should say that, shall be required to apply to the board for a new variance.
Oh,
Would it have to be new, Laura, if they were approved? Can they not come back with the same ask?
Well, if they already had a variance and it expired, then any other variance is going to be a new variance, because the old
Okay.
one's dead.
So they're not applying for an extension. They're-
No, new variance.
And can the zoning administrator grant an extension under this?
No, and so the issue is that the zoning permit, as we have it written now, is good for 12 months, and on our application, it states the zoning permit is good for 12 months. What needs to happen is this can be amended, but then our permit application needs to state, which is what I presented last month that we never got to, is I believe, and Laura, correct me if I'm wrong, I believe the language needs to state that a zoning variance is good for 12 months unless a variance has been granted, at which point it expires 1 year from the date of approval by the board or the granting of the variance. Because technically, the way it's written now, our zoning permit is good for 12 months. It doesn't differentiate between someone who's come in for a shed and someone who's gotten a variance. That's where the issue is that currently the way the language is written on the application is that it's good for 12 months.
But in reality, if a zoning permit is given and there's no building permit for 5 months, an extension of the zoning permit could be granted and has been.
So this is a Board of Appeals. This is not a zoning permit. They're two separate issues.
So the variance that we would grant would have the 1 year from date of our approval, period. And it needs to, in my estimation or opinion, to be crystal clear that action has to be taken by the applicant. I don't know whether we need substantial action in compliance with the variance.
We had that last month and it got struck.
Word.
It was in there last month and it was decided that substantial was not a good.
So it's
choice of word.
it's a variance and it's a permit. Those are two different issues. The variance has 1 year from approval by the board. And the permit is 1 year from by issuing by the administrator.
Correct.
So you could get, well, aren't we trying to pull those together and say that if it takes them 6 weeks to get a permit, it still goes back to the variance goes back to the original approval
Right, but
date.
this section of the ordinance is Board of Appeals. It's not zoning permits. That's a different section. That's a different.
So it's
And it doesn't, and the thing is our ordinance states, you know, when a zoning permit is required. And what I'm saying is the language on our application, which the applicant signs, is I understand, or I, the undersigned, acknowledge and understand, you know, that this variance or this, zoning permit is good for 12 months. That's how it's been as long as I can remember. It's not something I came up with. That's just what it's been. So when that permit is issued based on what's being approved, it's good for 12 months.
So that's.
And
But that's why I'm saying the language needs to change on the applications to be more specific to.
adding
The
a
variance.
substantial work.
That's
or
what I
the
was trying to
variance.
get last month, what by adding those in the packet.
So person A gets a variance granted by us
Mm-hmm.
on July first. That means that it's good, the variance is good till July first of 2026, right? Even if you don't issue the zoning permit until September.
Correct.
Okay,
Because they could get the zoning permit in September, they could turn around and get a building permit within a week or two later and start their project and commence. And that's typically how things happen. Sometimes people will get a zoning permit and then nothing happens and then it expires at 12
But-
months.
right.
But with the variance, that's where I'm saying the language needs to change on the application to be more specific. So that it states if there is a variance, it is only good for 12 months from the date of approval by the board.
And how do we know? Like, once the board grants the variance, how do we know when the zoning permit was issued and when the building, so that we
That
can be
wouldn't
aware?
matter. So let's say the board approves it today, July 1st, and they don't come in for a zoning permit until September 1st or 2nd, whatever. The clock starts there, but on a variance, it would then expire like June 30th of 2026.
Right, so how would we know that their variance had
You
expired?
wouldn't.
They don't have any report.
And there's no,
back
there's
to us.
no, there's no action that the board would take anyway.
Well,
But that's not,
Well,
Because the
The whole
permit is
issue-
outside of,
yeah, we want to know that when the year is up, that actually,
they have to come back to us.
yeah.
they don't have to, they could
Well, they
choose
could
not.
just, yeah, they could abandon the project. Like if they're not gonna go forward. Right? Is that what you're saying, Lisa?
Yeah, I was saying they don't have to, they could let the variance.
Oh, correct, but
And then they go no
if they're
further.
utilizing it, we want to know that at a year, the work of substantial character and the permits and whatever have
But
been
it-
accomplished.
Right,
Is that already on to the county?
Yes, it goes from a zoning permit to the county
Right.
for a building permit.
But
and
that variance is a part of the zoning permit, which goes to the county. So if they file for a building permit, if none of this is filed.
They would have they would have no knowledge of the fact that there's a variance.
And we would have no knowledge of, they've done no action. So the action is they get a variance, they go get a zoning permit, then they go to the county and the county takes it over. The county's responsibility is to make sure that the zoning variance hasn't expired or that they've started
No.
construction.
They
Well,
just
what
have to
we
make
wanna
sure there's a permit in
ensure is-
place, zoning permit in place. They need to know that before they issue a building permit. They won't issue a building permit unless a zoning permit has been issued.
I get that,
So
I know
that they
that.
don't take over a responsibility on our part. Essentially what happens is if our language is changed on the application that says it's good for 12 months from the variance being granted, that changes it. Right now, it says 12 months, it's good for 12 months. If they don't come in until 3 months after, it's good for 12 months, which is 3 months beyond when the variance technically.
Oh,
expires.
we're trying to understand what's the action? How is this monitored? And is there language that creates an action to monitor this? Or is that important?
Currently, they've got 1 year on a zoning permit, so that's what it goes off of.
And if
So
if it's
can-
expired, you just can't get a building.
Because
Well, you
there's
can-
nothing that says that I can restrict the zoning permit based on what it states, that it's good for 12 months from the date of issue. It's different if our language is changed so that it says if a variance is granted, it now expires 1 year from the date of approval. And then basically what I would wind up doing is on that approval, special condition would be that a variance was granted, this permit expires on, 365 days after the approval.
So what I'm.
And that would limit. how
Right,
long
so
that zoning
what I'm
permit
getting
is
is you've now linked, you are linking
the
variance
zoning permit.
with the zoning permit.
Correct.
Okay.
Yeah, and it would shorten that allowance. So if they decide to wait 3 months until they get their zoning permit, they're down to 9 months to get their work started.
Then, they're not responsible.
Would you, as a matter of course, check, I mean, look, we don't have that many things that happen in the course of a year for the ZBA, right? So would you, as a matter of course, check on those things?
Yes, if the language is changed.
You would check.
Absolutely.
So we're just linking The only thing we're really talking about is the language to link the 12 months of approval to the issue of a permit. So really, the permit, if there's a variance, the permit is only good from the approval of the variance.
That's how I would like to reword the language.
Yes.
Yes, it has nothing to do with when, the day they filed.
Correct, because
There
currently the way it's written.
no ability to alter or extend the we gave them 12 months.
Mhm.
And if they don't come in for what is it, building permit, that would
They would get a zoning permit.
zoning permit halfway,
Their clock's
their,
ticking.
the paperwork will show the expiration date of the variance and the obligation fully on your back. You must comply or it's dead.
And I can comply by starting construction, getting a building permit and starting construction.
So do you
That's
guys,
the
want-
only way
do you guys want
they could
to
comply.
rewrite this so it's
But
clearer?
this started because of Rose Street. He had started construction, he went fully into construction, but the variance had expired. The approval had expired, and he never came back.
So the permit, the zoning permit was good for 12 months. So that's where the clock starts. If we change the language to where if a variance is granted, that would restrict it to if he got approval in July and he came back in June of the following year, he's got a month.
He did nothing, neither,
He did.
both expired.
So
He did come back. He came back in June of the following year.
yes, that's what I'm saying though,
With
but
the drawings.
if the language were different to what I'm proposing, he would have had to have the work started by July.
Right, so you wouldn't.
So it would have expired and then,
And you wouldn't have extended.
yeah, correct.
wouldn't have-
The zoning permit would have been good for a month and then that's what he would have had to get that work done. So that's where my recommendation on changing the language on the application to state that. Now, Laura, I don't know, does that need to be stated in the ordinance?
Which part?
Sorry, yeah, we're all over here. As far as the zoning permit is concerned, which would be a different, obviously, different section than the Board of Appeals. Because currently, the application that we issue or we hand out that they fill out and submit states that a zoning permit is good for 12 months from the date of issue, period. It doesn't specify that if there's a variance that it expires 1 year from the date of approval or granting of said variance. Does that need to be in our ordinance for us to have that?
Yeah, the form is not enforceable. I mean, it's gotta be in your ordinance. If you're gonna enforce it against somebody and potentially,
Okay.
respect their rights, it's gotta be in the ordinance.
Okay,
And then maybe that second part could be cleared up a little,
Mhm.
run-on sentence.
Can't use bullets, right? I love a good bullet,
Maybe you can.
because there's like three conditions
Yeah.
by which this could be extended. And I
Yeah,
made a mistake.
we can certainly revise it. I think, like I said, the intent was to change it as little as possible to add what we were trying to add, but like many zoning ordinances throughout the state, this is written in a way that is, as somebody said, even with 2 master's degrees, sometimes hard to comprehend.
Right.
So do you need any more help from us, Lisa?
well, yeah, I mean, I need to know what your direction is, because I mean, if you want bullets, we could say no order of a variance granted. Well, I guess first of all, do you guys prefer option 1 where they have to come back and reapply, or do you like the idea of them being able to come back to the board and requesting an extension on an already approved variance?
No. I think they have to, it's a new variance and because maybe they changed something along the way. Maybe they were not clear about what they were going to do. Maybe they altered something. So what are you going, if you have to apply for a new variance, then you see actually what you're applying for.
then,
It
and
becomes
the
after-
ordinance could change too.
Near the end
With
of
that-
the
The
year,
ordinance could change
A lot
within a
can happen.
year if they haven't moved forward
Mhm.
with the work.
Yeah.
And so they have to come back for a new variance. It could be they've changed the nature of their project, or the city has changed an ordinance.
Regulations. Okay, so if we go with option one then,
And which is options here, I'm sorry.
so the second
So-
underlined title.
No, option one. Okay, got it. But are we talking about
So,
only number two?
So do you want to redo number one so that it says the first sentence and then within a year of the date of approval, the applicant shall and then say obtain a zoning permit, obtain a building permit, commence erection or alteration of the building and be progressing, and that could be number three. And then should the applicant fail to meet the above stated,
That's
does
very
that sound
clear.
acceptable?
Yeah, that whole paragraph is very clear.
Okay. So leave it as it is, or do you want me to list them out individually?
Well, do we need to say a zoning permit from the city and a building permit from the county? Does that, or is that just
I
understood?
think that's understood.
Understood, okay.
Mhm.
I think you should put like a number one and a number two and a number three.
Okay, so I'll have the first sentence and then the second sentence,
A, B, and
and then
C.
it'll say, yep, A, B, and C, and then,
Yeah.
and then there'd be the
That
last
might help
sentence.
clear it up.
Yeah, okay.
Love a good.
And then
And then there's a second line item,
And then
should
yeah.
it fail? Yeah,
Okay,
could even be another paragraph.
and then number two.
number two.
So this is the use variance. That's why this one's a little more,
Well, Laura said she could work on that.
okay. You okay with that?
Yep.
Not me?
And then, as far as changing the language to state that a zoning permit is valid for 1 year unless a variance has been granted. That whole tidbit
Where are you, Lisa?
it's not stated on here, it was what was on the application.
So
The
again,
sample. Essentially, the zoning permit is good for 12 months unless a variance is granted. In which case the permit is valid for 1 year from the date of expiration.
wouldn't you usually put if there's a variance, it's 1 year and a permit
No,
is subject to that, but the variance is
not on a zoning permit. Typically, zoning permits are coming through for anything and everything but a variance. The variances are few and far between. So it would be first and foremost would be the zoning permit is good for 12 months unless a variance has been granted.
unless a variance has been granted, and why not then actually put in, not just 12 months from the date of approval of the variance, but put a date in.
No, it's a blanket statement in the application and it would be in the ordinance as well. The actual permit that gets issued would state the date of expiration as 1 year from the date the variance was granted.
I understand. I just don't want, I want it crystal clear to the applicant. Here's a drop dead date.
Right.
Oh, don't you think that's clear if it says 1 year from the date of issuance to?
Of granting.
yeah.
Of granting of the variance.
And it can be specific to by the zoning board of appeals,
Yeah.
but it's very clear who's granting it.
Well, I mean, would it reference the date of the issuance of the variance? So
The
that they-
actual
that they know.
permit, the actual
The permit.
permit does, but not the language. The language would just be like, I understand and acknowledge, and then in our ordinance would state.
Yeah, well, we want, I think, fidelity to the whole process of, we granted a variance for a year, and we don't want it to be dropped in any way as the city works with the applicant, as it goes over to the county. We want it crystal clear. There it is.
Yeah.
Would the county be able, ready, and willing to, we see the deadline there. And we're inspecting and nothing's happened. So don't come the day later.
Yeah, so they would, I mean, my understanding is they would look at the expiration on that when they process the permit. So if they come in at the 11th hour and they've, you know, there's not enough time or it doesn't get approved, then they would look at the expiration of that timeframe. I mean, most people act fairly promptly.
Would that be Tom Dawes that we're talking about, or was it?
Not necessarily, no, Tammy's planning and zoning,
Any of those,
anyone, yes, they have, because it depends on if it's residential or if it's commercial, they have different. So Laura, the language that I'm referring to as far as the 12 months for a zoning permit and then the variance, I'm assuming that would go under our zoning ordinance section where we reference when a zoning permit is required.
Correct. Yep.
Which is, okay, so it would just be a matter of amending that portion as well. Which I can send that to you if you want.
Yeah, that's great. You can
Okay.
find, I'm not finding it quickly here.
Because it's pretty generic at the moment.
Are we still on number 2?
So it says zoning compliance permit, a permit required when there is any building change of use or changing footprint, including decks, accessory buildings, or temporary structures. That's under the definitions. I can send that to you with what I had previously submitted. So Laura's gonna work on number 2. So that being said,
That it?
well, I'm trying to figure out as far as our next meeting, we don't know when that would be, potentially, or next month, that's what it winds up being. Do you guys want us to draft this language so you can review it and then make the recommendation to the planning commission for consideration and amendment?
Right.
I do.
Can you just email that? Or we do it over email?
No, sorry.
Oh, come on, Laura.
I'm gonna take that as a no.
Public
Must be
meeting.
done in an open meeting.
Oh, are we open right now?
Yes. So no, that can't be done by email, it has to be done. in person.
Well, there's nothing,
Except for that we're not approved, it still has to go to the, I know, she rules.
No, yeah, this still, you are still making a recommendation, so that has to be done at an open meeting. You're not just doing this as private citizens, you're doing this as the ZBA.
We
So-
can meet to formally approve.
Yeah, we can be.
we
Yeah,
could
so-
have an August meeting, even if there's not
Correct,
anything to review, to take care of this.
correct, yep. Okay, so we'll plan to meet in August to review the proposed amendments. Article 20. And definition. August 5th. Do you have any applications for anything? Tomorrow at noon is the deadline,
But there's nothing yet.
not.
Probably not in the summertime.
Typically, all.
Yeah. Okay, we're going to get them. Are there
We can be done with that one, and then it's,
Are there any comments from board members?
So do we need this? thing, Joe?
No, she's gonna take care of it.
It's for your enjoyment.
I've enjoyed it enough.
I'm surrendering it, but would you like me to take the paper clips off?
no, that's.
I got markers and
Any
stuff like
comments?
that. I
Any
went
comments?
this, this.
The only comment that I could make is, I thought that we all tried very hard to do the right thing, but with the direction that was given by the judge. Done flying our best intellect, and we were very fortunate to have guidance from our council.
Yes, for sure.
I totally agree.
I appreciate that.
So ultimately, I figured this could have gone back to the permit office and they would have never got the permit. So we could have voted the other way and the same outcome would happen.
They've been in communication,
Wait.
they've been cited by the county, and they said they were not going to apply for a permit until we had decided what we were gonna do.
Correct. Because the architect would not
Right,
do any work with them.
right.
And she doesn't, and she was concerned because filing under a hotel, there's all sorts of other requirements, right, that they have to meet. And I could have gone the other way because I think it could have been on somebody else's shoulders.
Don't you know
And-
the builder that went to work for Wetland? Would you find that out?
I look him up.
Oh, really?
Yeah. Yeah, you know who it is.
Yeah.
Yeah, I mean, I know his parents and looked him up and.
Okay, any further comments?
No.
We should go off at
Here.
those meetings, shouldn't we? I mean, open meeting.
So we have a motion.
Make a motion, we adjourn. Oh,
Thank you, go ahead. Oh,
I'll make a motion, we adjourn.
A second.
all in favor?
Aye.
Okay,
Thanks,
thank you,
Laura.
thank you,
Oh,
Laura.
have a great night, everyone. Take care.
Hey, Laura.
Yeah. And